Hi. So today's narrated PowerPoint for this week is about civil rights. And some of the material in this PowerPoint is reiterated in some of the other assignments I gave you for this week. So for example, there is another video for you to watch about levels of scrutiny, and some of the reading in the annotated Constitution covers school desegregation and that kind of thing. So this PowerPoint will hone in on some of that stuff and add a little bit of additional information to it. So the focus of this narrated PowerPoint is the 14th Amendment and the equal protection of the law. We've already talked about some civil rights issues, including voting rights issues, and issues surrounding LGBTQ rights and that kind of thing. So we're going to talk specifically about the 14th Amendment and segregation and discriminate a little bit about discrimination. So that's where we're headed with this video. And again, sometimes my videos get long, so if you ever feel like your attention is wandering, go ahead and pause it and then come back to it and watch the rest of it some other time. You should also be taking some notes on these narrated PowerPoints as well. So the 14th Amendment has two clauses in it that are of particular interest to us when we talk about civil rights. And the next section of the course, when we talk about the rights of criminal defendants and people who have been accused of or suspected of crime. But what we're going to focus on in this presentation is the 14th Amendment's Equal Protection Clause. One of the clauses in the 14th Amendment is that everybody, no state, may deny any person in its jurisdiction the equal protection of the law. And at its very minimum, the intention behind the 14th Amendment was to prohibit states from enacting policies that discriminate on the basis of race. But for a very long time in our history, after the 14th Amendment was passed, shortly after the Civil War, the 14th Amendment was pretty much a broken promise. And there was a tremendous amount of segregation. These two pictures are historical pictures that demonstrate how the races were segregated or separated in many, many, many ways. So this picture shows that the black people and white people even had separate drinking fountains, and certainly train cars and cable cars and railroad cars, etc. Buses were segregated by race as well. The other thing that was part of the broken promise of the 14th Amendment was discrimination. So we've got segregation, which separates the races, requires people to be sort of socially separated from one another. And then we also had discrimination, which is a practice of refusing to hire somebody or rent them a room or provide them with services, etc. So segregation and discrimination are two separate things. And both of these things, discrimination and segregation, were very quickly after the 14th Amendment was passed, fairly soon after the amendment was passed, were given constitutional protection by the United States Supreme Court. And these two cases, the civil rights cases that were decided in 1883 and Plessy versus Ferguson, which was decided in 1896, are the early court cases that really made it very difficult for there to be any progress on civil rights for a very, very long time. So the private discrimination cases, it's a bunch of cases that were decided at the same time. In 1875, so long time ago, Congress passed a Civil Rights Act. And part of what Congress put in the Civil Rights Act was some fairly broad for their time prohibitions on discrimination against people based on their race. And a group of white business owners filed a lawsuit challenging the Civil Rights Act of 1875, and their argument, which of course the court accepted and made the law of the land, was that the 14th Amendment only extends, its reach is limited only to government action. And what the business owners argued is that their discrimination was private discrimination. They were exercising, for example, their constitutionally protected First Amendment right not to associate with people they didn't want to associate with. And in 1883, the Supreme Court sided with the business owners and gave constitutional protection to what we call private discrimination, or it's sometimes referred to as purely private discrimination. And so with that ruling, the court signaled that the 14th Amendment was going to be viewed really, really narrowly. It was only going to be protection against the sort of most egregious forms of government-mandated discrimination. And then shortly after the civil rights cases was enacted, the court ruled on another case, which is probably one of the most famous cases that we study when we think about civil rights in the United States, and that case is called Plessy versus Ferguson. And this is a case where I think most of you have probably studied this case before, but in Plessy versus Ferguson, the question was whether or not the state could mandate, without violating the 14th Amendment, segregation. So in this case, this case arose, I believe, out of Louisiana, but there were lots of states that mandated segregation, segregated schools, segregated train cars. Plessy versus Ferguson involved segregated train cars. And the Supreme Court ruled that simply requiring the races to be separate from one another is not a violation of the 14th Amendment. And they created what came to be called the separate but equal doctrine. The idea that as long as facilities are provided for everybody, the 14th Amendment does not require that those facilities be integrated, that it does not violate, the court said, the 14th Amendment to treat people differently in that way. So you can imagine how frustrating these two cases would be for anyone who was hoping that the 14th Amendment would provide some sort of real equality for people of color, but it really didn't. These two cases were pretty devastating in terms of stopping most real reform from happening. So eventually what happened was interest groups, in particular the NAACP, the National Association for the Advancement of Colored People, interest groups and elites were trying to get people to mobilize for civil rights and to push for new legislation and to push for the legislative branches and governors, state legislatures, Congress, etc., to pass legislation that would ease the burden on people of color who were suffering from segregation and from discrimination. But it was very hard to mobilize people because people tend to be pretty rational. And if it looks like every avenue for change is stacked against you, it can be very hard to get people to mobilize in large numbers. And once the court had signaled that state legislatures and federal legislatures were not obligated to ban discrimination or to ban segregation, a lot of the avenues for change, especially the legislative routes for change, really dried up. The federal government turned its attention to other things. They, after the civil rights cases, when the Civil Rights Act was struck down, Congress never really seriously attempted to pass any kind of new legislation in that area. And certainly state governments were the ones who were actively engaging in segregation, and local governments weren't any better in terms of pushing for civil rights. So what ended up happening was as new presidents got elected and openings came up in the federal courts, in particular, starting with Franklin Roosevelt, who was president, died in his 4th term in office. President Roosevelt had a lot of success in appointing a lot of people to the lower courts and also to the United States Supreme Court. And so what ended up happening is civil rights organizations, in particular the NAACP, began to see that there might be a new avenue for change, not through the legislative branches, but through the courts. And so what the NAACP did was they developed a strategy that's been used by many, many, many other civil rights organizations, women's rights groups, LGBT rights groups, Native American groups, disability groups. Lots of groups have taken a playbook out of the NAACP's strategy and developed plans to try to get social justice accomplished through the courts if they can't get it accomplished through the legislative process. But the NAACP was really the first interest group that ever did this, and that's why the work they did was so very important for other groups as well. And so as the Supreme Court became more liberal, the NAACP developed, as I said, this strategy to try to get the court to reverse its previous decisions. In particular, they decided they were going to really go after Plessy versus Ferguson and this separate but equal, because as a result of Plessy versus Ferguson, not only were cable cars and buses and school and drinking fountains, etc., segregated, but so were schools. And because getting a good education is so important for the economic well-being of a family, for a family's ability to prosper, education is, segregated schools were seen to be one of many things that were making it exceptionally difficult for people of color to progress in American society. So the NAACP decided that they were going to go after the separate but equal doctrine and see if they could get the courts to move in the direction of desegregation. But they recognized that if they tried to get the court to overturn Plessy versus Ferguson all at once, and then they failed, they would set back the course of civil rights for possibly decades and decades and decades to come. So what they decided to do was to try to get the court to actually enforce Plessy versus Ferguson. Most of us know by now, if you've taken some American history courses, that segregated schools were not equal. They were separate, but they were not equal. And so the NAACP decided that they were going to try to first get the court to enforce the separate but equal doctrine, and then see about getting the separate but equal doctrine itself overturned. And so they did this through a series of court cases. I'll give you a couple of examples. So the first case that they brought and that they were successful in winning was a case called Missouri versus Canada. Canada is a person, not the country Canada. So the state of Missouri did not have a law school for people of color. So separate? No. Not even separate but equal, not even separate. Missouri didn't have a law school for people of color. Instead, what they did was they offered to pay the law school tuition for people of color to go to school in another state. So the NAACP sponsored a student who wanted to go to a Missouri law school, and their argument was that if the separate but equal doctrine is a valid doctrine, then states are obligated to provide separate facilities. And if they don't, then they're in violation of the court's own policy, and then certainly in violation of the 14th Amendment. And the Supreme Court agreed. And in Missouri versus Canada, they said schools must provide, or states must provide, educational facilities for people of color. So that's one small victory. And if that had been the only victory, well, at least states like Missouri would have had to establish law schools. So the next step was to try to get the court to enforce the but equal part of the separate but equal doctrine. And the case that came before the court, where the court ruled on this, is a case called Sweat versus Painter, in which at issue was a law school, certainly provided, public law school provided for students of color, but it was of nowhere near the same quality as the state law schools that were available for white students. And if you're thinking about going to law school, you probably already know that it can make a really big difference what law school you get into. You know, it preps you to, not only does it prepare you to practice law after you've passed the bar, but it also might provide lots of opportunities for networking, opportunities to have a really good school on your resume that maybe will get you an interview for a good job, etc. And so going to a really lousy law school, and in this case, the law school had very few teachers, outdated books, hardly any classes offered, etc. It was clearly an unequal law school. The Supreme Court sided with the NAACP in Sweat versus Painter and said that if that facilities that are segregated must be equal. Wow, if they had never gotten anything further, then that at least would have been another step, right? But the granddaddy of them all, the cases, of course, was the case that was brought in, decided by the court in 1954, called Brown versus Board of Education, in which the Supreme Court ruled that segregation is segregated schools. They didn't strike down all segregation, but they did say that when it comes to education, separate schools are inherently unequal. Even if they have the same number of books in the library, even if they have the same high quality teachers, even if they serve exactly the same thing in their lunch, in their cafeterias, the fact that the choice has been made to tell students of color that they cannot go to school with white students stamps the students of color with a badge of inferiority and has real psychological impacts on students of color. And so these three cases paint a picture of how the NAACP, an interest group, achieved a bit of social change through the courts. It had been really the first time any organization had ever used the courts to try to get social justice change. It happens all the time now, but it was very new for its time. It was actually a pretty big deal. So what happened after Brown versus Board of Education? Well, in many places, nothing happened. States said, we've seen this court's decision. Let's see the courts enforce their decision, right? Courts can't enforce their decisions. They don't have police powers. It takes the people who are affected by the court case to be willing to implement the court's decision, because the court doesn't have the authority to implement it itself. And what happened after Brown versus Board of Education was a lot of school districts, in particular school districts in the South, just said, we're not going to do it. We're not going to desegregate. In fact, there were some school districts, one in South Carolina, which actually passed a law that said you cannot integrate your schools. And if you do, you're in violation of state law. And so there was a lot of pushback from the states against this federal mandate that the schools desegregate. And it took another court case to even get some desegregation started. I'm going to come back to this picture in a minute, but there's another really important court case that came to the court in 1958 called Cooper versus Aaron. And what had happened was Arkansas, the state of Arkansas, had decided that they were not going to desegregate their schools. And they were actually sort of making the argument that it was up to them whether they went along with the decision in Brown versus Board of Education. And so the Supreme Court had to step in again in 1958 and pass and make a new ruling that said that states are obligated to abide by the decisions of the Supreme Court. This is actually a really important case because what the court ruled was that states cannot ignore Supreme Court decisions just because they don't like the decision. And so they ordered, once again, the state of Arkansas to begin the process of desegregating their schools. And so eventually there was some movement to try to desegregate the schools. But then a new issue arose. The question was, if we're going to have to integrate our schools, how are we going to go about doing that? So some states implemented busing programs where they would bus kids from one neighborhood school to another neighborhood school so that the schools would be integrated. So students of color would get bused into white neighborhoods, or white kids would be bused into communities of color so that the schools would be integrated. And it was super controversial because it meant that some kids couldn't go to their neighborhood schools, and it was also, because there's a lot of racism in the country, there was a lot of pushback from white communities who didn't want their kids to go to integrated schools. And so, of course, desegregation policies got challenged in the courts. Sorry, had to pause there for a minute because my dog was barking. So two cases that happened post Brown versus Board of Education, in addition to Cooper versus Aaron, that are really important for the story of desegregation of the schools are this case that came to the court in 1971 called Swan versus Charlotte Mecklenburg, and this other case that came to the court just 3 years later called Milliken versus Bradley. And they involve two different kinds of segregation. So de jure segregation is segregation that happens because of a government action. So de jure means of the law. So in Swan versus Charlotte Mecklenburg, we're looking at a school district in North Carolina in which there were about 14,000 students in the school, and about 99% of the students of color went to segregated schools. There was hardly any integration. And so what the court ruled in Swan versus Charlotte Mecklenburg was that because the segregation was created by the school districts, they drew their district boundary lines in such a way that the schools would be segregated. They consciously made the decision to create segregation through the law. The court said that's the kind of segregation that the government can be required to fix under Brown versus Board of Education. So if the segregation happens because the government created the conditions for it to happen, then there is a legal remedy that can be imposed, whether it's busing, whether it's some other kind of program, but it is legitimate for the courts to mandate that kind of segregation be addressed. In Milliken versus Bradley, the question was, what about de facto segregation? So Milliken versus Bradley involved a school district in Detroit, Michigan, where the schools were segregated, but they were segregated without help, I guess, from the government. It wasn't government-created segregation. The segregation arose out of economic disparities where communities of color tend to live in poorer communities, and white communities, white people tended to live in communities that were wealthier. And so you had a lot of segregated neighborhoods, not because the government put policies in place that created the segregation, but because of housing patterns and job patterns and economic patterns, etc. And in 1974, the Supreme Court said that that's not the kind of segregation that Brown versus Board of Education mandates be remedied. So the court ruled in Milliken versus Bradley that de facto segregation does not require a legal remedy. And so what's happened over time, and this is what this chart shows, is that after some initial efforts to desegregate schools, schools are as segregated now as they were in the past in a lot of ways. We have a lot of, it's called resegregation, but even in modern times, this data is from 2017, so it's pretty recent data that shows that children of color are overwhelmingly likely to attend schools that are majority students of color, and very few white students actually attend schools that are majority students of color. So we have a lot of segregation still, despite Brown versus Board of Education, despite all these efforts to integrate our schools. When the court said that de facto segregation is just the way it is, and it isn't something that raises constitutional questions, any efforts to desegregate schools today, unless it can be shown that it's de jure segregation that is why the schools are segregated because of something that's in the law, it's hard to turn to the courts to get them to be willing to force governments to do anything about the segregation that happens in schools today. So it's still pretty controversial. There's a lot of evidence that links the type of school people go to economic outcomes. So if the schools that the children of color go to are in economically disadvantaged areas, and a lot of them are, that can have rippling effects on how many students go to college, what their incomes are going to be over the course of their lifetime, etc. So it's an important question. This question of de jure versus de facto segregation has really these cases have very important consequences for people. So I want to talk a little bit about discrimination, right? So Plessy versus Ferguson ushered in decades and decades and decades of segregation and making the 14th Amendment a broken promise on that area, in that area. But that civil rights case in 1883 ushered in decades and decades and decades of the other kind of potential violation of the 14th Amendment, and that is policies that discriminate, right? So remember, in 1883, the Supreme Court ruled that as long as it is not the government doing the discriminating, discrimination is not a violation of the 14th Amendment. So again, sorry, I had to pause again for a few minutes. I'm back now, but my dogs were barking again. So the civil rights cases of 1883 made it very difficult for people of color to get jobs, eat at restaurants, stay in certain kinds of hotels, etc., because there was a lot of discrimination. The civil rights cases in 1883 gave constitutional protection to what we call private discrimination. So in 1964, almost 100 years after the Congress had first tried to ban discrimination, Congress acted again, and they passed a law called the Civil Rights Act of 1964. And this law, it's still on the books. It's an extremely important piece of legislation. It outlaws most types of discrimination in hiring, in education, in businesses, and it's pretty broad. It covers race, it also covers gender, it covers religion, etc. It does not cover sexual orientation or gender identity. Those are the two really big things that are not covered under the Civil Rights Act. But the Civil Rights Act of 1964, and as it's been amended since then, does provide a legal basis for people to challenge the policies of even privately owned businesses, because the Civil Rights Act bans even privately owned businesses from engaging in discrimination. So you might be thinking to yourself, well, gee, if the court said in 1883 that private discrimination isn't covered under the 14th Amendment, the 14th Amendment only covers state action, how did the Congress get away with passing the Civil Rights Act of 1964? Well, I'll tell you. The Civil Rights Act of 1964 was not justified by Congress's power to enforce the 14th Amendment. The Civil Rights Act of 1964 was justified by Congress's power to regulate commerce. So there's a clause in the Constitution, in Article 1, Section 8 of the Constitution, that says Congress has the authority to regulate interstate commerce between states. And so what Congress argued in 1964 was that businesses are part of commerce. Even if they're privately owned, they're open to the public, which makes them subject to regulation by the federal government. If a person travels from one state to the other, they need to stay in a hotel. That's part of interstate commerce. If restaurants serve ketchup or Tabasco sauce, salt and pepper in their restaurants, they're getting their ketchup and Tabasco sauce, etc., through interstate commerce. And so Congress argued that they have a right under the Constitution to regulate commerce, and so they're going to exercise that power by saying that commerce must be done in a way that does not discriminate. In 1964, right after this law was passed, it was challenged. It was challenged by a group of white business owners, again, led by the guy who owned this motel, the Heart of Atlanta Motel in Atlanta, Georgia. And they argued, the business owners argued, oh, wait, we already did this. We did this in 1883. You already said, Supreme Court, that we can't be regulated. We can't be told that we're not allowed to discriminate. Obviously, this was a white-owned motel that did not allow people of color to rent rooms in the hotel. In 1964, the Supreme Court upheld the Civil Rights Act of 1964. Again, the court is pretty significantly liberal by this time. By the mid-1960s, we have a pretty liberal Supreme Court. And they accepted Congress's argument that this particular ban on discrimination was constitutional as an exercise of Congress's authority to regulate commerce. This ruling is really important because it means that businesses that are open to the public, that do business, that let people come in and do business, can be regulated by the federal government. That, we have minimum wage laws, we have worker safety laws, and we have these laws that say you can't discriminate against people on the basis of their race or religion or gender, etc. It should be pointed out that purely private discrimination is actually still legal. It's protected under the Constitution, mostly through the First Amendment right of freedom of association. But there's very little business that's considered private. So the fact that somebody owns a business that is open to the public takes it outside the realm of private discrimination. So for example, if somebody owns 2 houses and they want to rent one of those houses and take the income from it, that rental property is part of commerce and it's covered under anti-discrimination laws. But if somebody wants to rent a room in their own home, that's private. So there's very little that's really private, but a purely private organization, the one that most people use as an example is like a private country club, where you have to be invited to join the country club and you can only golf on the country club's golf course or play tennis on the country club's tennis courts if you're a member. As long as those businesses don't open up as long as they don't open up their golf course or their tennis courts or whatever to commerce, to the general public, then they can discriminate. There's very little that's still considered purely private, but purely private discrimination is still legal. The other case that comes to mind is a case that was decided, gosh, it was a long time ago now, I think sometime in the 1990s or early 2000s, where the Supreme Court ruled that because the Boy Scouts are a private organization, they don't get money from the government, they're not a government funded organization, they're a private organization, they can prohibit gay people from being Boy Scout leaders. So purely private discrimination, that case was decided. But most commerce is not private. Most commerce would be covered under the Civil Rights Act of 1964, including apartment rentals and any kind of business and hotels and that kind of thing. I should point out, The fact that something's illegal doesn't mean it never happens, right? Murder's illegal too, but we know murders happen. So it's illegal to discriminate, but that doesn't mean discrimination never happens. And if you have ever experienced discrimination, you know that it still exists. I'll give you a story. My sister's partner is Filipino, and he looks Asian, and she and he were traveling through the South. They camp a lot, and so they were traveling through the South, and they stopped in, I think they were in Texas, and Kathy went to walk the dogs while Tony went to have a beer. And when he came out of the bar, and Kathy said, "Well, how was the beer?" And he said, "Oh, I don't know. They wouldn't serve me." He sat there for 45 minutes at the bar, and the bartender never came up to him, never asked him what he wanted to drink. He couldn't get service. And it's illegal to not serve somebody because of their race or their gender, etc. But that doesn't mean it never happens. I've heard so many stories from students who have said they get followed around by security personnel when they go into stores, or they don't get served at restaurants. It doesn't mean it doesn't happen, but it does mean there can be a legal remedy. It means that somebody could file a lawsuit against the business for discrimination, and there could be a legal remedy, right? The business might have to change its policies, or pay a monetary fine, or do better education of its employees, etc. So I don't want to say that the Heart of Atlanta decision and the fact that the Civil Rights Act was upheld put an end to discrimination, because of course we know that that it did not. But it is illegal, which I guess is a step in the right direction. Okay, I am going to turn our attention to the very last thing that I wanted to talk about in this PowerPoint, and that is what we call levels of scrutiny. I've also asked you to watch a video about this, so now you'll get a 1-2 punch of levels of scrutiny. So I'm going to come back to this. It's a really nice visual, but I want to explain it without just making you look at it and learn it. So the 14th Amendment says that everybody is entitled to the equal protection of the law. It's a very important clause in the Constitution, but it needs some explaining. It does not mean that the government can never treat one group of people differently than another group of people, that there can't be differences in the law. But what it does mean is that the government is obligated to treat people the same if they are the same. So we call that being similarly situated. So for example, 2 17-year-olds, one's a boy and one's a girl, and they both want to get their driver's license. And they are identical. They've passed their whatever kind of driver training you have to get these days. They've had driver training. Neither one of them is legally blind. They have passed the driving test, but one's a boy and one's a girl. They're not the same gender, but they're similarly situated. They're kids who want to get their driver's license, and the law has to treat them the same. The law can't say, well, I'll give the boys their driver's license, but let's not give girls driver's licenses, or the other way around. Let's give girls driver's licenses, but not give boys driver's licenses. Now, a 17-year-old who has gone through driver training is not similarly situated as a 2-year-old, right? They're not the same age. And so the law doesn't have to give a 2-year-old a driver's license just because they're willing to give a 17-year-old a driver's license. But for people who are similarly situated, they need to be treated similarly. So that's a big part of these levels of scrutiny. And then what we add on top of that is that not all kinds of discrimination raise the same level of concern as other types of discrimination. So a law that says a 2-year-old can't have a driver's license, but a 17-year-old can, doesn't raise the same kinds of question as a law that says a black 17-year-old can't have a driver's license, but a white 17-year-old can, or a female 17-year-old is entitled to have a driver's license, but a male 17-year-old is not, right? So when the law discriminates and it's challenged, the question becomes, how do we decide what kinds of discrimination are allowable and what kinds of discrimination fall afoul of the 14th Amendment? And over time, the court has actually established that there are 3 different levels of review that a law could be subject to. So the first level is a minimum level of scrutiny. It's usually called the rational basis review. And laws that fall into this level of scrutiny are almost always upheld. They're hardly ever overturned because they don't raise the same kinds of constitutional questions as other types of discrimination. So what you can see in this picture is the court's going to give it a little bit of scrutiny if it's challenged, but they're just going to look at it through regular glasses, right? So they're not going to look too hard at the law. And types of discrimination that fall into this category, the only thing the government has to demonstrate is that they have a legitimate reason for passing the law, and that there's a rational basis for the law. So I'll give you an example. In the state of California, the law discriminates against drivers who want to talk on their cell phone while they're driving. Under California law, you may talk on your cell phone while you're driving as long as you are using a hands-free device. You've got some sort of Bluetooth, or your phone is, set up with Bluetooth, etc. But only if you're 18. Younger drivers, you have a driver's license, but you are not 18. Younger drivers are not allowed under California law to talk on their cell phones at all, even if they have a hands-free device. That law discriminates on the basis of age. Age discrimination, for the most part, unless you're over the age of 45, age discrimination falls under the rational basis of review. And so the only thing that the state of California would have to do if that law was challenged was to explain to the court, there's a reason we did this. We want to stop traffic accidents, and brand new drivers shouldn't be distracted. We want them to focus on driving. And the court would say, okay, that makes sense. That's a rationally related that fits the sorry, my dog's barking again. So the state of California would almost certainly win that case. Almost everything falls under the rational basis review. So laws that discriminate on the basis of income, like our income tax system, they fall under rational basis. They just have to make sense, essentially. Laws that discriminate on the basis of age up until a certain point also fall under rational basis. So other laws, like laws that say that you're not allowed to practice medicine unless you have a medical license and you go to medical school, those laws discriminate against people who would like to just hang up their shingle and practice medicine, or practice law, or cut people's hair, or whatever. We have all kinds of laws that regulate how you can do certain kinds of jobs, etc. So most of those laws would fall under, if they were challenged in the courts, would fall under rational basis review. The biggest thing that still falls under rational basis review that's controversial is sexual orientation under federal law. Lots of states have laws that prohibit discrimination based on sexual orientation, including the state of California, but there is no protection against discrimination based on sexual orientation or gender identity in federal law. So laws that are challenged in the federal courts under the 14th Amendment as being an unequal treatment of the law are subject to rational basis review. But the most recent cases that have come before the court has ruled that the discrimination on the basis of sexual orientation isn't rational. It's mostly based on animus or hatred toward LGBT community. The classic example, aside from Obergefell versus Hodges, which bans overturns bans on same-sex marriage is a case that came to the court in 1996 called Romer versus Evans. And essentially what Colorado did is they passed an initiative, they passed a ballot measure that said that that there is no protection against discrimination for LGBT people in the state of Colorado. And it went further and said local governments are not allowed to put in place their own protections against discrimination for LGBT people. The Supreme Court struck the law down. They said the only interest the state of Colorado has is that they didn't like gay people. And the court said that's not a good enough reason to allow discrimination. That's not a good enough reason to treat people unequally under the 14th Amendment guarantee of equal protection of the law. And so they struck that law. They struck that law down. Similarly, the court struck down bans on gay sex for the same reason. The intermediate level of scrutiny is mostly reserved for gender discrimination. It also applies to discrimination based on whether you were born in wedlock or not. But for the most part, most of the cases that come before the court under intermediate scrutiny are related to gender discrimination. So when a law discriminates on the basis of gender, and there really aren't very many left because most of them have been struck down, but when the law discriminates on the basis of gender, the court is more suspicious of the government's rationale. So they're going to give the law more scrutiny. They're going to pull out a magnifying glass and they're going to look more carefully. Most laws that discriminate on the basis of gender have been overturned by the courts. So this graphic says they have a medium likelihood of being overturned. They have more than a medium. They have a pretty good likelihood of being overturned. And then instead of just having the law have to be rational, the court requires more of the government. They say your purpose has to actually be important. Has to not be just rational. We'd really like to accomplish this goal. The goal has to be a really important goal, somehow related to public safety or providing an important government service or something. And that's a harder hurdle for the government to meet if they want to discriminate on the basis of gender. And so you can see that the interest has to be greater. And the law will be struck down if it doesn't rise to a level of importance for the government. And this level of scrutiny was actually established by the court in 1976. This was at a time when there was a lot of debate about whether or not we should have an equal rights amendment added to the Constitution. The court, in some ways, kind of took the wind out of the sails of the equal rights movement by creating this intermediate level of scrutiny and making it more difficult to discriminate on the basis of gender. And they did it in a case that actually benefited men more than it benefited women, funnily enough. The issue in Craig versus Boren was whether or not a state could allow 18-year-old women to buy alcohol, but limit the kind of alcohol that 18-year-old men could buy. So everybody gets to buy booze when they're 21, but some states didn't require you to be 21 to buy booze. Sorry, dog's barking again. This is the reason a lot of faculty are pushing to be allowed to get back into our offices so we can do our work. But anyway, that's my problem, not yours. So anyway, this case, Craig versus Boren, the court ruled that this law that allowed women to buy booze but not men to buy booze, it was sort of rational in a sense because men get into more drunk driving, young men get into more drunk driving accidents than women. But the difference was so slight that the court said, we can't just allow gender discrimination for the sort of flimsiest of reasons. So they created this intermediate level of scrutiny, and they said, from now on, gender discrimination is not going to fall under rational basis review. It's going to fall under this medium level of scrutiny. So it's going to be more likely that the court will not allow gender discrimination. And it's been used many, many times. So, for example, a law that said women couldn't go to military academies was struck down. The court has struck down laws that didn't allow women to be firefighters, for example, or police officers, etc. Lots of types of jobs that people might have wanted to engage in. Probably the example that proves the rule is a case from a case from the 1980s called Rosker versus Goldberg, where the Supreme Court upheld the male-only draft. Right? We don't have a draft right now, but the Selective Services Act provides for only men to have to register for selective services. So the idea being that if we're going to have a draft, women might not be subject to it. And in Rosker versus Goldberg, the court upheld that because at the time, women couldn't engage in combat. They weren't allowed to be in combat units in the military. That's now changed. So it's going to be very interesting to see if the reasoning that the court gave for allowing a male-only draft, they said having a draft is an important government interest. It meets the threshold. And since women can't be drafted, it makes sense to not have them have to sign up for the draft. It would be interesting to see if we ever have to have a draft again in this country, whether or not that same logic would prevail, because women can fight in combat units now. So we'll see. But anyway, that's the intermediate level of scrutiny as established in Craig versus Boren. The highest level of scrutiny that the court uses when it's evaluating claims that the 14th Amendment has been violated is what we call strict scrutiny. Again, this is the highest level of scrutiny. The picture here says that when a law that discriminates on the basis of race, in particular, is challenged, the court's not going to look at it with a regular old pair of glasses. It's not even going to look at it with a magnifying glass. It's going to look at it through a microscope. The government is going to have to be required to justify a law that discriminates on the basis of race with the highest degree of requirement. The government must have a compelling interest. In other words, the government must get something done, and they can't get it done unless they can discriminate on the basis of race. Laws that discriminate on the basis of race in this way have, since this level of scrutiny, are almost universally struck down by the court. So that's why we say that there's not a lot of legal discrimination based on race left overtly. But that doesn't mean there's no discrimination. One of the biggest issues, a couple of the two biggest issues that we still are debating in this country have to do with sentencing patterns and policing patterns. You're much more likely to get arrested, much more likely to get convicted, much more likely to get a longer sentence if you're a person of color. And we know that. Some people are working very hard to change that. We also see claims of discrimination in terms of the way voting laws impact different groups of people. So we know that in a lot of states, communities of color people have to wait a lot longer to vote. They have fewer voting places open than in some of the wealthier and whiter communities. And so there's a lot of debate about that. The court hasn't really ruled that those kinds of policies are inherently a violation of the 14th Amendment, but there are lots of people arguing on both sides of that. But generally speaking, if a law is written in such a way that it is pretty obvious that the goal is to treat people differently based on race, the court almost always overturns those laws. That's why we talk about institutional racism and sort of insidious racism, because the racism in the law today isn't obvious the way it used to be. You can't vote if you're black, or you can't apply for certain kinds of jobs, or you have to go to segregated schools, etc. It's much more subtle in a lot of ways than that. But Laws that discriminate on the basis of race are subject to strict scrutiny, and that is the highest level of scrutiny that the court offers. One of the things that I wanted to talk about is why race is protected against discrimination more than gender is protected against discrimination. And that's one of the last things that I'll talk about in this PowerPoint. So what the court has said is the reason race is subject to strict discrimination based on race is subject to strict scrutiny is because of how race has been treated in the law and in society for most of our history in this country. And so the court said that any group actually that meets these three criterion could be elevated to strict scrutiny. They have not elevated sexual orientation or gender identity. They have not elevated gender to strict scrutiny, but they say if these three criterion are met, then a group is entitled to strict scrutiny. The first thing is that the characteristic that is the subject of discrimination, the reason of discrimination is happening, is because of a characteristic that's immutable. And immutable means that you can't change it. So you can't change your race, for example. You can't change your gender identity. You can change the outward projection of your gender, but you can't change your gender identity. But certainly race is an immutable characteristic. And it's so discrimination that's based on something that people can't change, the court says we ought to be really careful before we allow that to happen. The second criterion that's necessary is that the group has to have suffered a history of political underrepresentation. So we talked before, when we talked about voting rights a little bit earlier, a couple of weeks ago, that there was, not only was the 14th Amendment a broken promise, but so was the 15th Amendment, that says you can't be denied the right to vote based on race. But we know that people of color have a history of political underrepresentation in this country, denied the right to vote, have a lot more difficulty getting people elected, appointed to positions of power, etc. And we know it's well documented that this is true. And so somebody might say, well, what about gender? How come gender seems to meet, women seem to meet those criterion as well? I mean, women didn't get the right to vote until 1920, and women are the most underrepresented group in politics, right? There are not 50% of governors are not women. 50% of the U.S. Senate isn't women. 50% of the House of Representatives isn't women, etc. Where gender failed, that race did not in the struggle to get strict scrutiny protection, is that the group has to have suffered a history of onerous discrimination. This is where the court let itself off with regard to gender. They said people of color have suffered from onerous discrimination, discrimination that was intended to harm them, that was intended to keep them from succeeding, to keep them from advancing. The court ruled that women have suffered discrimination, but the discrimination was not aimed to harm them, it was aimed to protect them. So again, that decision was made before there were any women on the Supreme Court, so not surprising that the court maybe would make that kind of decision. So what the court has said is that race gets the highest level of protection against discrimination. People of color get the highest level of protection against legal discrimination because of these things, because of the history that this country has in treating people of color. Like I said, for the most part, laws that obviously discriminate on the basis of race, a lot of them have been struck down. One of the remaining issues that is still legally debated, and because it's on the California ballot, I thought maybe we could talk just a little bit about affirmative action and how the court has looked at race-based policies that are designed to help people of color rather than hurt people of color. And that's generally what we refer to as affirmative action programs. So in 1985, in a case called Adarand versus Pena, the Supreme Court ruled that affirmative action programs are subject to strict scrutiny. They treat people differently based on race, and laws that discriminate on the basis of race, even if they're intended to help people of color, Adarand versus Pena involved whether the government could give people of color a little bit of a benefit when it comes to awarding government contracts for businesses to do transportation work and that kind of stuff. The court said in 1985, they struck that policy down, and they said laws that discriminate on the basis of race have to be subject to strict scrutiny, and that means the government has to have a compelling interest in the program. And they said that because the government was not actively currently discriminating on the basis of race, affirmative action did not serve a compelling government interest. It was designed to remedy past discrimination. And the court said, if the discrimination was in the past and the government's policies have been changed, then there is no longer a compelling need to have affirmative action programs. For the most part, there's not very much affirmative action allowed. In 2003, and then again in 2016, the court laid out a way that colleges and universities could have a little bit of affirmative action. In Grutter versus Bollinger, the court said that there actually is a compelling need for lawyers from all walks of life, and so they allowed the University of Michigan to have it's not a quota system, it's a policy where they take all of the applications together and they look at all of the applications as a group and base their admission standards in part on LSAT scores and grades and letters of recommendation and stuff, but also in part on the desire to create a diverse class of entering law students. So they can take race into account as a factor among many, income, etc., where they don't have a quota system, they don't have a percentage, they just want to make sure that the student body is diverse in a broad sense, not just racially diverse, but gender and income and where you grew up and etc. And the court said, okay, we'll allow that in 2003. And then in 2016, they said the same thing with regard to undergraduate, not just law school, but undergraduate. The University of Texas had a similar kind of program where they say, we want them, most of our spots go to students based on the ranking that they get when they take their SATs and what their high school graduation, they graduate in the top third of their of the state, etc. But we want to be able to give some spots to students to help diversify the student body, not necessarily because the student body itself needs to be diverse, but because of what people do with their educations and the benefit to society, to all different kinds of types of employment and businesses that people use. It's we have a compelling need, the state of Texas said, to be able to have a little bit of flexibility in our admissions process. And the court said, okay, we'll allow that. So most people who look at affirmative action say that it's sort of hanging on by its fingertips. And some people think, as the court's gotten more conservative, that at some point the court may rule that no affirmative action programs are allowable at all. But we don't know, because we'll see what happens. The reason I wanted to bring this up, one, it's kind of an important issue, but also because many years ago, the state of California, the voters in the state of California, actually banned affirmative action in California. They said it is illegal to use race as a factor in decision making for things like law schools or undergraduate schools or hiring in government businesses, etc. Government positions, government businesses. So in California, the voters voted to abolish affirmative action altogether. In California, there's a ballot measure on the ballot this year. So if you go to vote within, between now and the 3rd of November, if you cast your ballot, one of the ballot measures in California on the ballot would overturn that proposition and would allow for limited affirmative action in California to the extent that the Supreme Court has said it can be done. So if that ballot measure passes, then the UCs and the CSUs and government businesses could, if they chose to, within the confines of these decisions in Grutter versus Bollinger and Fisher versus University of Texas, start to develop some types of affirmative action programs that are currently banned under California state law. So watch this space. We'll see what happens in the election. Anyway, that's all I have to say. So I will end. Thank you for listening.